ago, this subcommittee met before an empty witness chair in a hearing the majority knew would yield no new information. One thing did happen during that hearing that could have advanced our resolution of this matter. I challenged the majority to present to the American people and the minority the evidence it believes justifies the continuance of this investigation. I challenged the majority to cite and produce specific hearing testimony, interview testimony, or documents demonstrating that in this case there is a critical question that remains unanswered and can be answered only by information from Harriet Miers or other White House sources, such as White House documents at issue today. The silence since I issued the challenge is deafening. The majority did not present evidence at that hearing. The majority has not presented that evidence since. I draw one conclusion. The majority does not have the evidence. We are here today to consider a ruling on the executive privilege claims of the White House that the White House has asserted over its documents and lining up contempt citations for Harriet Miers and the White House. Once the majority obtains that ruling, it presumably will go on to contempt proceedings over the refusals based on those claims to appear, testify, and turn over documents. These games may be strangely entertaining to lawyers, press hounds, and academics, but they are not parlor games, and they promise no productive end. On the contrary, they pointlessly threaten to land in jail people who are asserting understandable claims to executive privilege concerning evidence we don't really need and that we could have had and still could have if we were willing to take up the months-old White House offer of informal discovery. Instead, we're placing Harriet Miers and Josh Bolten in the crosshairs for refusing to give us information when we ourselves for months have refused the White House's offer to give us precisely that information voluntarily. This investigation began with the outcry over the dismissals of 8 U.S. attorneys from the very party whose leader, President Clinton, dismissed all 93 U.S. attorneys in 1993. It continued just last week when the majority overruled executive privilege claims Harriet Miers forwarded, even though they rested on the legal opinion of Janet Reno, President Clinton's Attorney General, that immediate advisors to the President, specifically including the White House counsel, were absolutely immune from being compelled to testify before Congress. There's one thing I want to assure everyone that everyone understands. If this body votes out a contempt citation and that citation is sent to the U.S. Attorney for prosecution to pierce executive privilege, then this body will be committing precisely the kind of partisan abuse the majority has decried from the outset of this investigation. In fact, the majority will be forcing the U.S. Attorney to pursue a political case. The majority will be engaging in the sort of activity they are accusing the Justice Department of. The only difference is there is no factual evidence that the Department has engaged in that sort of behavior, only innuendo. It is a core responsibility of Congress to oversee the executive branch. But after all the investigations we have done on this matter, it has resulted in no evidence of wrongdoing in the removal of the U.S. attorneys. Instead, we have damaged the Justice Department, diminished Congress, and have landed at the threshold of contempt proceedings against Harriet Miers and the White House. We anticipate a court battle which I very much fear we will lose. By we, I mean the Congress. If we don't have substantial evidence of wrongdoing, we will perpetually undermine Congress's prerogatives in overseeing future administrations. So I renew my challenge to the majority. Produce the evidence they believe establishes wrongdoing in the U.S. Attorney's dismissals. Cite and produce specific hearing testimony, interview testimony, or documents demonstrating that there remains in this case a critical unanswered question that can only be answered through contempt proceedings. Because without that evidence, there not only is no basis for ruling against the White House's assertion of executive privilege, there is no basis for proceeding further with this investigation. There's no basis for doing anything other than wrapping this investigation up. We need to get back to the real work of the American people.
Will the gentleman yield?
Madam Chair, and I would be pleased to yield.
Thank you. I just want to clarify something. I want to make sure that everybody here present understands that this hearing is not the correct place to hash over the extensive evidence that our investigation has uncovered. There will be a time and a place for that, but there is no good reason to take the subcommittee's time to argue those details right now. As a legal matter, the committee has no burden at this point to prove that wrongdoing occurred. What we need is fair access to the information we have subpoenaed to responsibly be able to make those judgments, and that is what the matter at hand, that's what brings us here today.
I believe that the purpose of this hearing is to vote on whether or not to proceed, and that vote ought to be informed. And in fact, I believe that what we're doing here today is remarkably dangerous for the future of the prerogatives of this body, and therefore I believe we ought to have exactly the debate that you're saying we should not have. And at some point in the very near future, we're going to have to produce that evidence. The majority is going to have to produce evidence that will convince a U.S. attorney and then a court.
Will the gentleman yield?
I'd be happy to yield.
There will be a time and a place for that, and rest assured you will get that opportunity to hear that evidence.
Reclaiming my time and seeing this expired, I would tell the gentlelady that I look forward to that time and yield back.
Thank you, Mr.